Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy!
Have them send someone with more experience.
Alrighty. We're gonna get right to it this morning. Oh wait, this evening. Yes, it's not morning yet, though it might be by the time we finish. Oh my goodness, we have so much to go over tonight. Surprise! We have another live stream. Welcome to the Court of Public Opinion. I am the recovery addict. It is so great to have you here tonight. Thank you to Jules. Jules gave me a call and said, Scott, have you seen the document Greg just posted? He just dropped it. It's in the Maya trial. It's a response to what JHACH said at the hearing on Friday, and it's good. And I said, I'll go live. Hold tight. It's a document. I pulled it down. We're going to share it here together. It's going to be amazing. And let me just say, well, the music is playing. It's the wrong music, but happy birthday to everyone. I realize more people have a birthday today than any other day we've ever had people have birthdays. So happy birthday to everyone who's celebrating. And yes, a little happy birthday there. That said, we are going to stop. Oh, I can't stop it. I forgot I put latch. Put it on pause. There we go. Now it's reset, so it's not paused. All right. We have a couple things to go over before we kick this off with the document. Erica 843. I believe this is a first offense for you, Erica. You're first in chat. First in chat comes with its own prize, punishment, or penalty, depending on how you view it. And that is, we sentence you with internet ownership, and you're responsible for taking care of everything on the internet for everyone else. It's not really something you can brag about, although it does look good on your resume. So you can always claim that, and if they need a reference, you can have them call the burner phone. I'll do that. But congratulations, Erica. The internet is all yours to take care of. So expect a few calls tonight, maybe overnight. You say woohoo now, but just wait. Congratulations, Erica, on being first in chat. That's awesome. Thank you for being here. We always love the first person to talk in chat. That sort of gets the conversation going for the rest of the show. That said, we have one of my favorite people, one of the people I've got to meet in person for the first time on Friday, and that is Greg Anderson, Attorney Greg Anderson, who's representing the Kowalski family against JHACH. And on Friday, I was down there in person in the courtroom, got to watch the hearing take place and listen to the arguments made by both sides. It was absolutely phenomenal to be there. It was incredible to meet the people who were there, meet the family, to meet the players, and see the judge, see the courtroom, see things as they sort of unfolded. It was really, really neat. I know it wasn't the courtroom, but it was a courtroom, and it was great to be there and be able to stream that and bring that back to you guys through that. But tonight we have an updated document. Some new things came up in that hearing that we were not expecting. There were some filings that were made by the defense that the plaintiff had not seen yet, and so, as is fair, the plaintiff gets to respond. And Greg Anderson did that. He just barely posted the document on the feed, on the courtroom docket, and it's 78 pages long. And it's wordsmith artistry, and it's wonderful. And so we're going to bring it to you tonight. I've got a little bit of water. My kids I've told them to continue bringing more. I've got like 3 more bottles down there. So we're going to do a read through, and we're going to make it quick because I know you guys have stuff to do, and some of you might have to watch this on the rewind or on the replay, but that's all right. Jules is the best Maya doc finder. She is wonderful. And meeting Jules was awesome as well. She wasn't there in the courtroom, but we were able to meet up afterwards and have lunch together. Jules was just wonderful. So thank you very much, Jules. Midge, yes, Alicia. We've got many, many wonderful people here. Thank you, all of you. All right, let's cut to the chase, shall we? Where's our document? It's gonna be right. Not there. Nope. Other direction. There we go. There we go. It's on this one right here. So let me go ahead and make this full screen so I can see what you guys see. This is, make it a little smaller. Hey, bud. Thank you. I'll need those. They were there the whole time? Well, these ones are cold. I'll start with them.
Just because I just got one from when you started.
Oh, thank you. Let me finish this bottle off, and then we'll have a spare one right there. So we're going to read all of it, 78 pages. Yes, this is live. This is live. We're going to read this. This just barely dropped. This afternoon. Went live on the docket sheet. We're going to read it to you, bring it to you first, and tell you exactly what the plaintiff is thinking about what the defense said on Friday, because they did bring some interesting things up. They sunk to new lows, and some, in my estimation. But here we go. Let's get some water down. Oops, a little bit fell on my audio board. It'll be okay, I think. No sparks yet, so. Okay, well, I'll ask for a new one for Christmas. How about that? I won't get it. All right, so let's go ahead and kick this off in style. First of all, this is it's dated today. Up at the top, it's e-filed. Well, the 18th, 4:51 p.m. It takes a couple hours for it to show up on the docket. And does the audio board have a B button? Not anymore, Amber. Not anymore. But it's great. Debbie Long, welcome to the gallery. Thank you very much for your continued support. Love that yellow courthouse by your name. Thank you. That's at least 6 months of support there. Don't you dare ruin our audio board. Thank you, Lat Cali girl. All right, let's get to reading. Read it already, says Jules. Oh no, Jules says I read it already. Yes, Jules was ahead of everybody. So here we go. We're going to read it together. Plaintiff response to the defendant's third supplement, proffer of affidavit at December 15th hearing, the motion for juror interview. All right. Having failed to articulate any grounds to justify an interview of juror number 1 in its previous motions and supplements, the defendant produced a third-party affidavit at the time of the hearing on December 15th. Plaintiff's first opportunity to review the affidavit was during defendant's argument on its various post-verdict motions attacking juror number 1. Having withheld the affidavit until the last minute, defense counsel was able to facially argue that there was a non-disclosure on the part of juror number 1. So defense, basically, they held their cards so close, they didn't even let the defense know what they were going to file. They just went to the judge with a new argument, and plaintiff's like, hey, we haven't heard about this, right? Astoundingly, this is another instant of defendant willingly and recklessly misleading the court. Juror number 1 did disclose on his juror questionnaire that he or an immediate family member had been charged with a crime at question 18B. Juror number 1's disclosure on his juror questionnaire demonstrates that both the defendant's first supplement, based on the 20-year-old domestic court issues, and the latest affidavit are frivolous and could have been explored by the defendant. Contrary to defense's counsel assertions during the hearing, defense counsel asked no questions about the crime response at question 18B on juror number 1's form, nor any questions of the other jurors who said they or an immediate family member had been charged with a crime, the victim of a crime, or a witness in a criminal case. The record proves that defendant did not consider the information material, at least not until the defendant lost. The plaintiffs prayed the court not reward defendant Johns Hopkins All Children's Hospital for its continued attacks on juror number 1 and multiple bad faith attempts to mislead this court. Oh, bad faith. Ooh. The defendant has targeted juror number 1 and viciously attacked him and his wife, and now his wife's son, in a post-verdict effort to undo a 9-week trial based on the post-verdict research of juror number 1's life going back more than 20 years. So let me look at this little subnote here. Said the defendant had in fact asked questions of jurors who answered any of the crime questions in the affirmative. In responding here, the plaintiff learned that the defendant had never even ordered the transcript of the jury selection process. The court said, "Let me ask you this, and I haven't gone back to look at all the juror questionnaires, but were there other juror questionnaires where the juror checked a family member's been a victim of a crime, and then did your side ask questions of those individuals?" That's what the judge asked Mr. Shapiro. Mr. Shapiro responded, "I haven't gone back through all the voir dire. In fact, defense counsel had not gone through any of the voir dire before making their latest reckless assertions. As discussed further below, having had the $7,500 privilege of ordering the transcripts and performing the due diligence, defendant should have performed before further disparaging juror number 1 and making false claims about what the defendant would have done. plaintiff can conclusively demonstrate that the defendant has asked no questions, whether or not a potential juror or one of the juror's family members had been charged with a crime or the victim of a crime was simply not an area the defendant was concerned with or ever explored with any of the 12 jurors during the multi-day jury selection process. So continuing on. Along the way, the defendant has doxed juror number 1, publicly releasing his address with reckless disregard to the safety and well-being of both him and his family. Defense counsel later implied juror number 1 harbors neo-Nazi attitudes and employs neo-Nazi symbology. Symbology. That's a weird word. That one's new for me, Greg. And throughout, defense counsel has repeatedly misrepresented the record, i.e. the introduction of the phrase creature comforts into the trial, and now misrepresenting defendant's lack of diligence during jury selection in an all-out effort to destroy juror number 1. Defendant wishes to cajole this court to allow just an interview of juror number 1 on fairness grounds based on defendant's argument that although each of its premises to justify the interview fails individually, when viewed collectively, the false premises must amount to something. The defendant will never stop with just an interview. As defense counsel admitted during the hearing, the defendant has already demanded juror number 1's private communications and text messages along with those of juror number 1's wife, along with those of Jules, notorious Agent Jules. Fairness extends far beyond the immediate considerations here and will broadly impact the jury system and citizens' willingness to serve on juries if a citizen's entire life will be scrutinized post-verdict simply because a citizen turned juror renders a verdict adverse to a dysfunctional corporate defendant. Thank you, little Larry. Appreciate that. Little notes here says, let's see. Note number 2 was in reference to... Didn't see where that was. Oh, right up here, going back more than 20 years. Although defense counsel was uncomfortable divulging defendant's sources at the December 15th hearing and again dodged the court questions, defense counsel has turned to the netherworld of Reddit into the defendant's research arm and continues to file meritless challenges based on nothing more than the latest conspiracy theory dredged from Reddit. The SS supplement and the proffer of the affidavit are the latest examples. And then in reference to Jules, it says, even if the court accedes the defendant's request for interview of juror number 1, the defendant will next press the court for private communications between juror number 1 and his wife on this road to nowhere, since the defendant cannot overcome the husband-wife privilege set forth in Florida statute. Leaving the potential ruinous effects of the jury system and public policy considerations aside for the moment. So set aside the fact that this would ruin top secret Agent Jules. I like that, Alicia. This would ruin the whole judicial system, the jury service system we have. However, the defendant's latest attempt to call juror number 1's service into question based on the last-minute production of a third-party affidavit fails for at least 3 reasons. 1, the defendant has not met its burden. 2, the defendant's challenge based upon the third-party affidavit is pure artifice as demonstrated by defendant's pattern of questioning, or more accurately, failure to question during the multi-day jury selection process in this case. And 3, defendant waived any challenge based on the third-party affidavit and public record in the related case. Defendant has not met its burden. Its actions show the question was not material to it. The defendant has again failed to meet the high burden to interview or disqualify a juror post-verdict and set aside 9 weeks of judicial effort. The Florida Supreme Court reaffirmed a 3-part test for whether a juror's non-disclosure of information during voir dire warrants a new trial. Case law, it says, for the initial prong, the complaining party, that's the defense in this one, must establish that the information is relevant and material to jury service in the case. Here, defendant contends an alleged non-disclosure by a law enforcement officer that he was the victim of a crime, a verbal threat, was material to its decision to keep juror number 1 on the jury. This is demonstrably false. In Roberts, the case law, the Supreme Court held that materially must be analyzed on a case-by-case basis. Materially is only shown where the omission of the information prevented counsel from making an informed judgment, which in all likelihood would have resulted in a preemptory challenge. We have studied the record. Further, we have studied the record and see nothing in the pattern of preemptory challenges to suggest that Murphy would have stricken juror Moore if the information had been disclosed during voir dire. Now, that's the wording out of the existing case law that he's referencing, the whole Murphy and juror Moore. That's not this case. That's the case he's citing. In other words, under the 3-part test set forth in Roberts, defendant needed to show that juror number 1's responses on his juror questionnaire prevented Johns Hopkins and its jury consultant from making an informed judgment. and that the defendant would have exercised a preemptory or perhaps cause challenge if juror number 1 had checked 18A yes instead of no. Defendant cannot meet this burden. In presenting the affidavit at the December 15th hearing and attempting to argue some sort of prejudice from the late discovery of a public record, defendant's counsel did not represent that he would have exercised a preemptory challenge, even when the court inquired. Defendant was unable to commit to the premise that it would have challenged juror number 1, and the record supports defendant's ambivalence. Juror number 1 did check yes to 18B, that he or an immediate family member had been charged with a crime. In follow-up, defendant's counsel and its jury consultant asked 0 questions of juror number 1. Had defendant's counsel asked any follow-up questions regarding question 18B, juror number 1 would have disclosed the circumstances described in the affidavit. The simple fact is that defendant's counsel and defendant's jury consultant had stars in their eyes when the first juror, juror number 1, to be brought in during the individual questioning turned out to be a former law enforcement officer. Defendant believed that its defense would resonate with the former law enforcement officer who would understand the criminal implications of Munchausen's by proxy. Allegations against Beata would understand the intricacies of DCF and the dependency court system and would surely relate to Detective Stephanie Graham. Defendant did not exercise due diligence, as demonstrated by defendant's failure to ask juror number 1 any questions and by failing to challenge jurors who answered affirmatively to crime questions on the juror questionnaire. Lawyers representing clients in litigation are entitled to ask and receive truthful and complete responses to the relevant questions which they pose to prospective jurors. More case law. During defendant's tennis challenge, based on the affidavit, this is case law, defendant repeatedly cited to the 3-part test reiterated in this case law, defendant cannot meet the 3rd prong, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. They didn't ask this question. They didn't chase this rabbit, right? And if they didn't chase the rabbit with anyone else, him neglecting to announce that he was, had been a victim of a crime, they wouldn't have chased that rabbit either, is what the plaintiff is saying. Defendant did not ask any questions of juror number 1, even though he answered affirmatively to another crime question on the juror questionnaire. Nor did the defendant demonstrate due diligence in asking other jurors follow-up questions when they answered affirmatively to the crime questions on the juror questionnaire at questions 18A through C. Defendant's lack of diligence cannot be used to assail the adverse effect under both De La Rosa and Roberts. Defense counsel confessed during the December 15th hearing that they had not performed the necessary analysis to demonstrate its due diligence. The record belies defendant's purported concern and newfound position that it viewed the responses to questions 18A and C on the jury questionnaire as material to the defendant's considerations and informed judgment during jury selection. So they say, hey, these questions were important to us back then. And we would have, had he answered differently, we would have made a different choice. But the evidence says they weren't important. They didn't ask follow-up questions of anyone who answered affirmatively on these. And so they would not. And it wasn't important then, and they can't claim it is now. In fact, of the 12 combined jurors, both primary and alternates, 6 answered affirmatively to questions 18A through C. Defendant selected those 6 despite their answers to questions 18A and C and asked 0 follow-up questions on the topic. See juror questionnaires of jurors 1, 17, 19, 97, 106, and 137. Compared to transcripts of the jury selection, selected excerpts, attached as composite A, jurors 1, 17, 19, and 97 decided this case despite no inquiry by defense counsel regarding the crime questions, and astoundingly, jury number 106, the first alternate and newfound love of the defendant, oh my goodness, newfound love of the defendant, was among those who answered yes to the crime questions. Still, defendant did not inquire further. Taking these 6 in order, he's done his work here. Oh my goodness. Let's see. Amber, is there stuff I need to... oh, okay. Let's see. Oh, that's the juror questionnaire. Okay, so when we get to the juror questionnaire, I'm going to redact it. So we're going to use the redacted version so it doesn't show up everybody's names and things. We're not going to show that. Yes, Kurt, there's a new... Greg Anderson filed a response to the plaintiff's motions that they made new motions, new filings the day of the hearing on Friday. Didn't tell plaintiff at all. They just presented it to the judge in argument without warning to the plaintiff. And this is a response to that, 78 pages long, and we're tearing through it. So the 6 in order. Juror number 1 checked yes to 18B. During individual voir dire, the court inquired about juror number 1's affirmative response, and juror number 1 disclosed that his stepson had been charged with the crime. Defense counsel asked no follow-up questions and, in fact, asked 0 questions of juror number 1, even though his stepson had been charged with the crime. Juror number 17 also checked yes to question 18B. During individual voir dire, the court inquired about juror number 1's affirmative response, and juror number 17 disclosed the court inquired about juror number 1's. I think that's supposed to be 17 right here. And juror number 17 disclosed that his son had been arrested 5 years ago. Defense counsel asked no follow-up questions and, in fact, asked 0 questions of juror number 17, even though his son had been charged with the crime. Juror number 19 checked yes. During individual voir dire, defense counsel focused heavily on juror number 19's awareness of Take Care of Maya and her Catholic religion, but asked no follow-up questions regarding juror number 19's affirmative response to the crime question. Juror number 97 checked yes to both questions 18A and B, and during individual voir dire, the court inquired about juror number 97's affirmative response, and juror number 97 disclosed that her son had been charged with a crime in 2014 or 2015. Defense counsel asked no follow-up questions, and in fact asked 0 questions of juror number 19, even though her son had been charged with a crime. Had Mr. Shapiro asked any questions to follow up with juror number 1, the defendant could have learned more about the crime that juror number 1's stepson had been charged with. Importantly, the affidavit relates to that alleged crime. Juror number 106 checked yes to 18B. During the individual voir dire, the judge, had asked about the affirmative response, and 106 disclosed that his son was charged with a drug crime. Defense counsel asked no follow-up questions and, in fact, asked 0 questions, even though his son had been charged with the crime. And juror 137 checked yes to 18A. And during the voir dire, defense counsel asked no questions of that 137 despite affirmative response to a victim of crime question. Glaringly, 27 of the first 200 potential jurors answered affirmatively to the crime questions. Defendant's counsel and the jury consultant demonstrated abject apathy and complete failure of due diligence on the topic of being either the victim of crime, charged with a crime, or witness in a criminal case. The record reveals that the defendant failed to follow up on even one prospective juror's answers to the crime questions. While defense counsel represented to this court that he was certain that if juror number 1 had disclosed that he was the victim of a crime, there would have been a cause challenge, and if not, a preemptory challenge, the record reveals the exact opposite. The court cannot take defense counsel at its word. Oh, he's saying you can't trust him. You can't trust defense. The court cannot believe what these officers of the court are saying. The court cannot take defense counsel at his word for what he would have done because juror number 97, one of the final 6 jurors that decided this case, disclosed that he or she was or a member of her immediate family had been a victim of a crime and charged with a crime. Not only did defense counsel fail to ask juror number 97 any follow-up questions related to her crime answers, but defense counsel also did not use either a cause or a preemptory challenge, despite vehemently conveying to the court at the December 15th hearing that he would have if he was juror number 1. Plaintiffs' counsel has reviewed the transcript of voir dire for all of the 27 of these potential jurors questioned on days 1 and 2 of jury selection, but does not include all the excerpts here in the interest of brevity. Mr. Shapiro said, "As your honor can imagine," this was on Friday, "had that been disclosed, that certainly would have led to a cause challenge, if not a preemptory, if a cause challenge was denied." Those are the 2 ways they can say, we don't want this juror. One is they say, "You're judge for cause." There's a reason. The court can see how obvious it is this person cannot serve on the jury. It's they're not fit to serve on the jury. They clearly cannot be, impartial. I should have to use yours. Okay. What page does that start at? That's just the attachments, right? Amber? Send me a text or something. Let me know. I've got the one you sent to me, but I just don't want to show the non-redacted version. The court needed look no farther than defense counsel's failure to inquire of juror number 97, the red cow juror. Hello? What's the red cow juror? Is there an inside joke we don't know? They must have like a red cow on the shirt or something. I don't know what that means. For proof that defense counsel would not have exercised either a cause or preemptory challenge based on an affirmative response to 18A. Juror number 97 checked yes on question 18A, and defense counsel did not exercise any challenge. The record conclusively demonstrates that defense counsel was not focused on affirmative answers to crime questions during voir dire, and defendant's informed judgment was not impaired by anything but its myopic view of ridding the jury pool of all the women on the veneer. He calls out, yeah, we need more information about this red cow, Kurt. He calls out the defense for trying to get rid of all the women on the veneer. Remember when we heard that they're trying to get rid of like single mothers and young mothers off the jury? That was someone's impression. And Google searches for red cow just spiked for some reason. Telling juror number 106, the first alternate juror, tellingly, juror number 106, the first alternate, this is the one that we would have had we dismissed juror number 1. I'm trying not to read your comments, Kurt. I'm ignoring them. It's not communist cow. Also had son charged with crime, yet without any knowledge of the circumstances of that crime, the defendant moved to substitute juror number 106 for juror number 1 during the trial. Had that scenario played out, juror number 106 would be subject to the same post-verdict attack by the defendant here on display here, since the defendant failed to exercise any due diligence in determining how number 106 affirmative response to the crime question would affect his view on the evidence of the testimony in this case. In sum, defendant's lack of due diligence cannot be used to assail a verdict adverse to Johns Hopkins. Defense counsel spent more time making clumsy pie analogies during the jury selection than exploring the criminal conduct of any juror or any juror's family members. I need these pie analogies. I need this. Is red shirt cow fighting brown shirt cow, or is this part of the jury selection conspiracy? Kurt, this has to be something that red cow, red blue gives you wings. I don't know. It has to be something that she was wearing, or a comment that clearly the judge can relate to or knows who they're talking about. Maybe somebody in court might know. All right, clumsy pie analogies. We need that information as well. Here's the third prong. Defendant waived its challenge based on the affidavit. Defendant's supplement is defective because the verbal motion was not filed within 15 days of the verdict and is thus untimely under Florida law. And the verbal motion was not sworn, which the second district holds is required. Oops. The defendant has not substituted any sworn allegations regarding the affidavit and the presupposed prejudice, and defendant's statements on the record are counterproductive given that defendant was unable to represent that it would have conducted its questioning any differently. Defendant's failure here mirrors its failures to preserve its earlier post-verdict attacks on juror number 1. The affidavit has been public record and was at all times leading up to and during the trial. Over 20 years ago, the Florida Supreme Court stated, the court system is already overburdened and does not have the luxury of allowing jury verdicts to unravel or be subject to attack because of information which could have been reasonably obtained before the trial begins. Switch to my document in ModChat after page 13. I will do that. Let me get this sent over to my laptop. Thank you, Amber, by the way, for redacting this for me. This is quite helpful. Let's turn on Wi-Fi. Send it to MacBook Pro. There's some pages, because this is a jury questionnaire, some of the jurors fill out information that might reveal their identities, and Amber, one of our great mods, has gone through and redacted that document to hopefully not show any of those identities. It may not be, we may not read everything because it's literally just a copy of the jury questionnaire, the forms they filled out, but in case they do show up on the screen, we want to make sure. Oops, why did that not work? Is it still downloading? Let's try that again. It is not loading, Amber. Let's see if it transfers in a document form. Nope. Thanks. I'll check the email. Thank you, Amber. So I've got after page 13, but we'll get there. Let's keep going. I've got everything on here. I should have done this on StreamYard, Kurt. I need to learn to use StreamYard on this so I can bring people in. Defendant's failure here mirrors its failures to preserve its earlier post-verdict attacks on juror number 1. The affidavit has been public record. Jedi Jen, welcome to the gallery. Sorry, I had to insert that. Welcome. Great to have you as a new supporter. The affidavit has been public record and was at all times leading up to and during the trial. Over 20 years ago, the court said we can't unravel things. We got there. Everything defendant is complaining about is a matter of public record. The defendant cannot use information it could have known ahead of trial and well before the adverse verdict to justify a new trial. Defendant did not deny in the December 15th hearing that it knew all the items complained about in its initial motion through counsel Ethan Shapiro and his wife's extensive internet activity. Shapiro's wife got in there again. To have known the conduct and not complained until after the verdict was a waiver. That's what this is key right here. This is why they say they waive it. They knew about it and they didn't complain about it. So this is the monopoly rule, guys. We talked about the monopoly rule, right? If you're playing Monopoly against your friends and you roll your dice and you move your character and you land on their space and they forget to charge you rent, and then you start going and your next turn comes around, you go again and you go around again, and they're like, wait, you were on my space, you owe me. It is too late. It is too late. The court views this the same way. It is too late. You had an opportunity to complain and say, hey, you have to pay up. This is, there's no redos. You can't go back. You can't go back. There was a time when you could complain and you didn't. So monopoly rule, that's my phrase. Monopoly rule is in effect here. So to have known of the conduct and not complained until after the verdict was a waiver. Okay. Defendant's latest effort to justify hang on one second. Red Bull, Red Cow, says Lily Wayne. Was it? Did the witness come in or the juror come in with like a Red Bull to jury selection? That would be hilarious. Be all amped up for answering questions. Defendant's latest effort to justify a new trial, and before that, a juror interview based on the affidavit and an alleged non-disclosure of juror number 1 must be denied. If the court grants an interview of juror number 1 and juror number 1 dispels any notion of misconduct or non-disclosure, that will not be the end of the matter. This is not plaintiff speculation. Rather, the defendant has already admitted this, stating at the December 15th hearing that even if juror number 1 performs perfectly during any interview that is permitted, the defendant will be back to the court with additional discovery requests and demands the text messages and electronic communications between juror number 1, his wife, and the public observer known as Notorious Agent Jules, who defendant pejoratively and erroneously refers to as plaintiff's agent. And he said this. It just about floored me when I heard this during the hearing. But they said, yeah, we'd like the jury interview, but we're pretty sure, they're probably going to say the same thing you said all the time. It won't be enough to do a juror interview. We're going to also need the text messages between the juror's wife and Jules. Just think that through. Draw that connection. We're going to ask the court to require two people who are not party to the case, who have completely two members of the public. We're just going to do a forensic scan of their phones just to see if we can find something. It's not going to happen. It is not going to happen. Okay. In a case where the bad conduct of a defendant was on full display, where the defendant elicited false testimony and withheld material information. Oh, wait. Yeah, that's right. Regarding its dysfunction, where the defendant refused to produce cell phones and text communications until 15 hearings were held. And even then, the majority of the phones and text messages were destroyed by defendant and its agents. Now the defendant wants to turn a Florida citizen and his wife into public enemy number 1 and treat juror number 1 as an adverse party in order to enforce discovery standards and compel production of text messages that the defendant would not honor. The judge says, you can't do this. You can't, with what they've done, with what they were supposed to turn over, the phones, the messages they were supposed to turn over, that the phones just went missing mysteriously. I don't know. They're down some well in Kansas. I don't know where they went. He says, you can't let them get away with this and then let them turn around and request this information. Not only will any potential juror interview not save the court from defendant's reckless charges of the court abusing its discretion, the defendant will not rest until it has completely destroyed the reputation of juror number 1, obliterated the husband-wife privilege, and done irreversible harm on the jury system in Florida and beyond. The court will have better luck teaching a fish to foxtrot than getting the defendant and its counsel to refrain from filing frivolous motions and litigating and appealing and otherwise doing everything they possibly can to delay the conclusion of the case. Where's the fish to foxtrot reference come from? Does anybody have that? Teaching a fish to foxtrot. I have to be careful how I say that. Teach a fish to foxtrot. Is that a movie reference? It's a beefish. Yes, it's a beefish. Hold on. We're gonna see if this is a movie reference. Okay. The closest thing I could find is Teaching Fish, Reading Foxtrot, and Making Sense by Larry N. Campbell, who's the Aftermath Enterprises. I don't know what that is. Teach a Man to Fish. That's not it. How to Train a Fish. I think he just came up with it. It's a new saying. It's a Greg saying. All right. All right, so we're teaching a fish to foxtrot. Wherefore, the plaintiff respectively requests that this honorable court deny the defendant's motion for a new trial based on juror misconduct, motion for a juror interview, motion to open discovery into evidence of juror misconduct, an emergency motion to preserve evidence, and all its various supplements, and award sanctions for the reckless and callous statements within the motion, and for any other relief the court deems just and proper. Respectively submitted, Gregory A. Anderson and friends, signed by Mr. Elliott. And it's certified. There we go. All right, so here we have to be careful now, because now we're on a new page. Hang on just 1 second before we scroll down further. The fish is in the foxtrot. When you have someone or something right where you want them, most commonly used in a adult manner. So here's, before the Patriot Colts AFC Championship game, Julian Edelman asked Tom Brady, "Are the balls deflated?" And Brady responded, "The fish is in the foxtrot," and winked seductively. I'm reading this. Where's this from? Urban Dictionary. So it must be true, right? Urban Dictionary. Apparently this is it. So let's cut right here for just a minute while I look at our exhibit. Okay, they are redacted. I've got redacted version as well. Amber, the latest version shows redacted on my part. Lots of redactions. So let's see. We have. I'm keeping this. Make sure there's nothing on here that I can't show. Okay, let's go to 3. Here we go. All right, so this is the jury questionnaire, prospective juror questionnaire, and it's got the name. We believe this is juror number 1 because it says number 1 in the corner, and you've got all the questions about where they live, English, marital status. It's a quite thorough background. It really is. Retired, law enforcement, children. What do they do? Ages, hobbies, recreational interests, camping, kayaking, just good stuff. For teaching fish to foxtrot. Thank you, Angie. That is awesome. Thank you. Do you know the judge? No. Lots of no's. Clearly, this is one they had a problem with because there was somebody on here, potential witness. There was a no. He didn't know, but his wife might know or something like that. It's way down there. I forget which one it is. It was a potential witness there. And then you've got the crime questions, which are down here in 18. Let's see, where are they? Oh, that's a supplemental questionnaire. Let's see, in the matter of excerpt of individual question of juror number 1. Okay, we're going to be careful here. Okay, we're gonna do this. We're gonna cut again, because I can't make sure that they're not including addresses here. Those are all the lawyers. So this is a text document of the transcript of the juror proceedings, which are wonderful. It's on the first page. Amber, so the first page is now redacted on the court website. So I think we're good. It may have gone up initially without the redactions, and then it was redacted before I got it. These are the questions. I'm not going to go into all the details here because it's got a lot of information about the juror specifically that's not important to us, right? This is him sharing and being open about his family situation, about things that happened in his life, and frankly, it's not important. Let's see. There's another page, also redacted. Let's see. Where's 18? These are questions for juror number 14. These are all the examples of the jurors of what the defense did. This is a questionnaire for juror 19, what they said, and then what questions were asked by the defense. So this is the thing. Greg Anderson did all the homework on this. Mr. Shapiro shows up in court and can't even tell the judge. I mean, he tells the judge that had they known, had he checked this box, had juror number 1 check this box, we know, the question was, have you or a family member been a victim of a crime, charged with a crime, or witness to a criminal case? Had he said yes, we would have said, we want him off. We want him off. There's no way we want him on his jury. But all these other jurors checked yes on these boxes, and they did nothing. They didn't ask anything about it. So Mr. Anderson's position, it seems like to me, is that basically the judge can't trust, meaning the defense, lied, misled, the court in how they made this motion, because their evidence shows otherwise, that they would not have had taken that action. Juror number 97 has a questionnaire here as well, with everything that comes from all the back and forth. Juror number 106. I love. Okay, you got to see this. Just one second. Juror number 106 asks these questions, and we're going to show it just like this. So he says, there are these yes, no. Do you know any of these people? And they're checking no. And it gets a little tiresome. We know that because check out this next page. Get to the next page and they just draw one line, just no all the way down. Nope, don't know anybody. Next line, no all the way down. Don't know anybody. And that's just a big line through everything. And this was juror number 106. This is the one they wanted. The one juror who just crossed everything off with one big line. It's like, nope, it's not me. And the questions for juror number 106. Juror number 137, the same thing. Lots of no's on everything. Juror number, let's see, Amber's on the phone. Hang on one second. Hey, Amber, how's it going?
Good. How are you?
I'm doing great.
Obviously, I'm not very clear in my chat. Future saw it and said 10 times the charm. So the question 18 that they're talking about in the questionnaire is on page 1, and it says exactly what I typed out. And you can see the responses for yes, no to each of A, B, C for every one of the jurors for that questionnaire.
Okay, page 1, 18.
It's like just under half of the page. Everything pertinent is redacted, so you're fine.
So it's.
I looked at the newly posted one.
Okay, so have you ever been a victim? Have you or a member of your immediate family ever been a victim of a crime? Yes or no. Charged with a crime? Yes or no. And a witness in a criminal case? Yes or no. And we have a variety of answers. Like some say yes, I've been charged with a crime. Says juror number 19, but they don't do no investigation. They do no follow up on that question, which is just remarkable. So this really shows that I think the defense are scrambling. They're trying to throw anything they can at the wall to make it sound good in court.
I'm going to go ahead and hang up before my 3-year-old tries to start talking to everybody.
Okay, we'll see, Amber. Thank you very much. Okay, bye. I wasn't going to read the transcripts and answers. Jules, and this is the reason. Jurors who are called into voir dire have to answer all sorts of questions. It's a lot like sitting on the stand and not being able to plead the fifth, right? You have to talk about things that are very personal, details in your family that may not be, they may be public record, but might not be public. And there's situations that might not be comfortable to be publicly discussed. Those questions are included in there, and some of them they're sensitive. That's it. They're sensitive, or can be. So I'm not going to go into that with each of the jurors. I don't think that's pertinent for us to know that in this case the defense didn't ask any questions, about people who ask this question. This response is just to this new motion that the defendant filed right there on December 15th in that hearing without notifying anybody. And it sounds like he did it improperly, did not do it timely, waived it with the affidavit, and also the argument he made to back it up was not in good faith with the court, that it's not believable. Man. So the good news is most of this document is attachments that we're not going to read because they're just little check boxes. Questions about self-deletion of someone they know. Those are some of the things. I'm not going to go into that. Joe Shapiro didn't ask any questions of everyone that answered yes to the crime stuff. I see that, and that's what Greg spelled out, and this is the proof. Basically, Greg made the argument in the motion, and then he attached all the proof for every single one of the jurors. The important part is summarized in the motion itself. So now here's the question: with this updated information, does this impact the judge at all? Does the judge get frustrated and say, "Hey, you're trying to mislead the court, or you're not being fully truthful. You're not doing your homework. You didn't put in the effort that you should have when you should have. So we're not going to grant this motion." Or does the judge say in order to keep the appearance right, so that there can be no doubt as to the validity of the verdict, we're going to go ahead and do an interview? That's the question. Jen, I'll say this. I think the judge will still proceed with the interview, even though there was nothing I saw at all in the motions. There's nothing I heard that I said, well, there's a problem. Yeah, that's an issue. I didn't find any of that. So I think he still will do it. I think it will be very brief, extremely brief. There will be no cell phone analysis. There will be no text message subpoena. That's not going to make it at all. But the judge, he almost set the date, right? He said, hey, so if I decide to do this, or you guys happen to be free on January 3rd, about this time, I think that might happen. I know Kurt has said otherwise, and Kurt is a very smart man, so I take a very dangerous position here, disagreeing with Kurt, because Kurt is often right and I am often wrong. But we'll have to see what happens. The judge is going to make a decision about midweek on this, right? So we've got just a couple days to decide if he wants to do an interview. Sherry says, interview maybe, but I don't believe he'll order cell phone records. I agree that the cell phone records is so far down a path that they should not even be contemplating about taking. Kurt is extremely intelligent. I agree with this wholeheartedly. That's why he is a lawyer and I am not. Kurt thinks granting the interview in an effort to do all that is good and right. All right. Just for that purpose, do you think the judge got backed into a corner and he has to? Do you think he's in a situation where he's put so much effort? Kurt, I'm asking Kurt here. He's put so much effort into making sure that this verdict is appeal proof, right? That he's trying to make it be perfect. The judge should be sua sponte, issuing sanctions, not bending over to JHACH. You use some words I don't know what they mean, Kurt, right here. I'm going to have to Google it. You went Latin on me. Define sua sponte. This is, Cornell EDU says, Latin for of one owns accord voluntarily, used to indicate that the court has taken notice of an issue on its own motion without prompting or suggestion. In law, it describes an act of authority taken without formal prompting from another party. The term is generally applied to actions the judge taken without prior motion or request from the parties. So the judge should be doing that to issue sanctions, not bending over to JHACH. The judge now has further proof that defense is mucking about. Is this not a case the lawyers behaving in contravention to the law they profess to be bound by and reportable? I don't know about the reportable part. I will say that I heard a very wise lawyer say, unless you are directly involved in a case, you shouldn't be filing complaints to the bar about them, right? I think that's great advice. So I don't think any of us need to do anything to try to make anything happen in this case. I believe our best efforts can be done in observing and talking about it publicly. But let's see. It was way more friendly than the first way I intended to phrase it. I was a little disappointed in the hearing that the judge did not rain down fire and brimstone on the defense for still refusing to turn over the documents that he spoke so clearly and so eloquently and so lengthily on. He was quite verbose when he talked to Miss Correll's about this and made it very clear that she should pass all this information on to her co-counsel, that he would look very harshly on any efforts to fail to do exactly what he had asked, and that was to turn over anything with a scintilla of odor about the IJ. And then here on the 15th of December, after the verdict, they still have not turned over the documents and are still fighting it and now saying, well, what does it matter? It doesn't matter anymore because we didn't and we lost, so you shouldn't get them anyway. Let's see. Where do you find the documents? KRH, sorry. These documents are found at through the court clerk website. So sarasotaclerk.com is where I go. You do have to sort of make an account there. These ones are free. Florida is really good about having open records that way. A lot of places are not as free and need or request payment. But if you want a good place to find documents that have been found for you and put together, this Discord page, which is a group that it's not my Discord, but is a group that we've been friends with for quite a while. This is As the Gavel Drops. They have an amazing true crime inventory and library of documents for just about any case you can think of. So you might want to check that out. All right. You're live again. What happened? Documents dropped in the Maya case again. You can do it via guest login. Taylor Myers, the fix, the thing is guest login doesn't remember like prior cases. So you'll have to know exactly what the cases you're looking for and know how to search it. And some of these search tools on the court clerk websites are a little wonky. They're going to require special formatting of the search fields to make sure it works right. So in this case, like we've got 2018 space CA space 005321 space NC, and that's going to be the case number. And if you get the spacing off or a number off or something like that, you're not going to find the case. But that's how you find it. And if you have an account and you log in, it will remember prior accounts, and you could just say, oh, here's a search I did before. Click on that, and it'll bring you right back to that one. Think interview leads to a slippery slope, says Laura Bronson. Very. The interview is too far, right? When you look at even though they have all these reasons for an interview, not any one of those reasons appear to be valid in my opinion. Not any one. None of those reasons meet the standard on its own to show that there's a problem that affected the outcome, and they should get to delve into this to see more. And by saying that we have all these reasons that don't count, if you add them all up, they do. The math isn't there. No matter how many times you add a zero, you don't get to 1. 0 plus 0 plus 0 plus 0 plus 0, it's still 0. And they're saying, look at how many zeros we have. This should add up to at least 500. It doesn't work. It doesn't work. Let's see. If I am the tuft of justice, Bliss Lamb, I know what you're referencing with the tuft of justice. If I'm the tuft of justice, Shapiro and Hunter will be in the county jail till every single document is turned over. That also was not going to happen. But I would like to at least see the Judge Carroll, at least show a little more spine and back up his own order that was disregarded. I would say blatantly. Didn't come here to math, says Cachette. So the judge said he might do the interview because of the hint of impropriety. Did this document clear that up in your opinion? This only addresses one part of that, Hope Always. It only addresses one part. All the other parts, they still are zeros to me. But the only reason I think the judge might still do the interview is because he's been trying so hard to make sure this stands up to any appeal. And if he does this, then there's, it's one more thing that says, see, there's nothing there. We checked. We turned over every rock. We didn't have to, but we did anyway. And it was good. It was solid. The decision stands. There was nothing done inappropriately. But Daddy, there is no scintilla of odor in my room. There's a scintilla of odor in those boxes, I think. All right. Did you read all 79 pages? That was speed reading. No, we ended up having a lot of. We ended up having a whole ton of documents that were basically copies of the jury questionnaires. The judge seemed to want to do it because it's cumulative. M. Young, I hear that a little bit. I'm not sure if he wanted to do it. There were a couple points where the judge, in listening to arguments and listening to the counter arguments that were made, seemed to say, hypothetically, let's say I get to this point. Say I'm with you. Then what? And he did that for both sides. And so I'm not sure. I think he really played his hands close to his chest here, and we didn't get to see his cards very well at all. There was just one moment where I think we would, and that was where he made that comment about, do you think that another hospital would have battered Maya? That was about it. Okay. Let me know if you're going to go live, Kurt, and we'll do a thing. We'll do the thing. Let's see. Anything else that was? There's a volcano that's erupted in Iceland with very much like the defense motions from the trial. I have not followed any of the world events since this began. Bella says, AWOL, I see I'm still a member. I have lots of excuses. Merry Christmas if I don't see you before. Love, joy, peace to all. Thank you, Bella. I appreciate you. It's all right to be AWOL and come back when you can. Should have set up a poker cam. We playing cards? Oh, we are playing cards. I said the judge was playing his cards close to his chest. I actually like watching poker. I don't play it myself, but I like watching it because I don't like losing. That's why. True Crime Junkie, the OG, says, I'm just so happy that all of you are invested in this like I am. No one wants to talk about it with me anymore. I'm sorry, True Crime Junkie. We're going to have a couple more things that are coming up. First of all, the judge making his decision when that files. It's not going to be in a hearing, right? It's not going to be like everyone show up to court. The judge has something to announce. It's going to be filed a lot like this. It'll be a ruling that hits the docket, and maybe it will be. It might be scheduling a date for a jury interview and asking the two teams to come down. I think if they do the interview, the judge seemed to think, like, default it would be in public, right? It would be here in the courtroom. These questions would be asked in public. And that goes a long way for public perception of how effective it was. But I think it's very negative on the whole jury, the willingness of anyone to serve on a jury. The chilling effect it has on potential jurors in future cases, I think is really high. If you can go and serve on a jury and do your best and follow the instructions and not do anything wrong, because we don't have any proof he did anything wrong at this point, and then get dragged into court publicly and be grilled on whether or not you did everything right. I think the chilling effect is terrible. It's terrible. That would, no one will want to. Everyone will be Googling, how do I get off serving on a jury? That's what's going to be like the #1 Google search if this goes through. There are also court papers regarding them not giving the IJ report posted today also. I saw those. There are a couple documents from each side that have been posted. Scott, I have a question. Do you think Judge Carroll likes to sing Christmas carols? Well, it's in his name. What's in a name? Christy Devers, I made a live finally. Curious how JHACH isn't denying care to kids with cancer to keep paying Shapiro. I bet he's not working pro bono. Nancy, I don't know. I think the hospital is still doing what the hospital's done as far as care goes a long way. And I will say that there are probably hundreds and hundreds of families out there who are singing the praises of JHACH and saying, JHACH saved my child's life. Thanks to the hospital, thanks to the doctors, thanks to all this. The hospital does good work. And I'm not by any means coming down on the hospital saying that they are, the devil or related to, anything SS related. I'm not that person, right? I'm not the person that's just anti-hospital. There are incredible people that do incredible things in incredibly challenging situations, and they wear scrubs, and they come in with a smile and give people hope and cheer people up and put an arm around a grieving parent. And I mean, I'm just saying, hospitals are amazing. The work that nurses and hospitals and doctors do is incredible. In this particular instance, I believe that JHACH let everyone down. Let everyone down, and that's why I'm speaking out against that. Let's see. I'd like to cover the third-party affidavit at the time of the hearing on December 15th. Are you going to cover that tonight? Because we can let me know. Give me the word, and I'll steer people your direction, Kurt, if you want that. Don't think it's posted on the docket. You can even sit on social workers' laps at JHACH. It's like Santa Claus. How can the defense get away with all this and not have the court judge to shut down and sanction them? Darlene, they haven't necessarily. I mean, look at this. They got a verdict against them on all 44 counts. On all 44 options, they lost. It was a clean sweep that way. So that they're not really getting away with it. There is still, all those sanctions are still sitting out there. The judge has reserved. He's going to say, I'm going to decide those later. First, we're going to handle the juror interview issue. That's going to be the first thing. I'm not going to look at anything else until that's decided. That's going to be decided this week, probably maybe as early as Wednesday. And then once that's handled, okay, we're not going to do anything until after the juror interview, because if there is something there, that changes everything, right? And if there isn't, then we can move on. But we look at like the first week in January, and then we move on, and that's when we look at remittitor if the judge is going to knock down some of those amounts. We look at the motions for a new trial, which probably won't happen, especially if the juror interview is either denied or turns out to be a complete dud and contain nothing that the defense thinks it would contain. But all those things get decided, and then after that, once those issues are handled, there's the judgment that gets entered, and that's when the judge brings the gavel down and says, "All right, we've adjusted the numbers as far as we're going to adjust. We've handled all these other issues. Now I'm ordering you to pay." And as soon as that gavel hits the block, the timer starts, and it starts accruing interest. And if the amount stays the same at about $261 million, I think it works out to about $56,000 a day of interest that is just adding to what the hospital would owe the family. And that is not a small amount. So you look at what the lawyers make, and let's assume they make, I don't know, $500 an hour. Shapiro might laugh and say, I make much more than that, or I wish I make that much. I don't know. But let's just assume he makes $500 an hour. The cost for having those, 5, 6 lawyers, however many people they send to court to fight these issues and file new motions and drag things out, is going to be weighed against how much interest they're accruing in the same time. Because the hospital is paying both. They're paying their lawyers, and they're paying interest, which that money adds up very quickly. And that is every dollar, as Mr. Shapiro knows, every dollar they pay towards interest is a dollar they can't put towards a new MRI machine, or expanding a wing in the heart center, or something like that. It's a dollar that can't go to care. That the hospital says, we would rather fight this issue than just pay out. So they might not get away with it. And once that's what I was getting to your question. I left it hanging there. Once that judgment is entered, there's also going to be the talk of sanctions. The judge is going to come down and say, now we're going to address the issues, everything you did wrong, the problems, the lies, whatever it is he decides that is valid and deserves a sanction, deserves a penalty or punishment. they can do that. And it might just be you owe XYZ lawyer fees to the legal team, the team that had to fight this. If you made a motion and you didn't do your good faith investigation behind it, and you misled the court and everything else, he might say, look, for all the time that the plaintiff had to fight that and do the research, for the cost of getting the transcript, for their time and hours, you have to pay for it. And so it's like adding to a fine on top of that. And where else he can go, I don't know. I don't know the limit of what he can do with sanctions. Let's see. Public flogging. Probably not that extreme. I don't know if it's possible that that sanctions could include things that could impact a lawyer's career legally. It's possible that they could go that far, but I don't know if they would in this case. I googled red cow, has something to do with the sacrifice. I don't know, says Jules. Oh man, Runkle's live as well. What is Runkle? Let's see. What is Runkle talking about? Give me just a second. And Brandy's on Verdict Watch. Let's see. Oh, he's doing Monday Legal Fun Day. Okay, I see. I told Kurt we would go to Kurt, and it looks like he has one coming up. Let me check it here. It is coming up tonight in about 15 minutes, so we're going to go ahead and reroute that way. Kurt, I'll wait till it's just before the time, and then I'll transfer over. Might give you a second to get going. Oh, it looks like a good friend might be in the chat. Let's see here. Where is... Well, there he is, Dr. Joe Corcoran. Dr. Joe, thank you very much. I have to say, Dr. Joe was a gracious host and allowed me to stay at his place on Thursday night. Drove down for 13 hours, stayed at his place, and was just an incredible host. He pulled a great prank on me while I was doing the live stream from his house. Assuming I was in the right house, I was worried that somebody else would come through the door and I would be in the wrong home. But no, it was really funny. It was a lot of fun. He also introduced me to the legal team, introduced me to the Kowalskis, and then also treated us and some friends to an amazing lunch at the breakfast company. So Dr. Joe, thank you so much. That was the most amazing trip. It made it possible, and it was wonderful. It really was incredible. So thank you very much for all of that. And I've been singing your praises. I talked to my wife today, who made cinnamon rolls, and my wife admitted that the cinnamon rolls that we got from the breakfast company, which she got to taste because I drove home and did not eat them the whole time. Those cinnamon rolls are better than hers. That's her saying that. I would never venture into that area, but she says that the cinnamon rolls that your wife makes are better than hers. But I will not weigh in on that one out of self-preservation rules. Hands down, hers win. There she is. That's my wife. Homeschool Ground Zero. Thank you very much, Mrs. R.A. You're an awesome guest, and you're welcome back anytime if you bring Mrs. R.A. That's the thing. I need to bring my better half for sure. I will say that Florida driving down was not the scenic route. It's not driving through the Grand Canyon. It's not driving through the Teton Mountains. The vistas were not incredible because the weather was also not very great. It was very windy and cloudy the whole time. I did get to see some really cool things, and I loved watching the scenery change out the windows. But driving there in Sarasota across the bridge, headed west out of Sarasota there into the Gulf, and looking back in my rearview mirror and seeing the lights of Sarasota, and just so beautiful, with a mixture of all the lights from the Christmas lights and all the lights from all the buildings. It was absolutely beautiful. I haven't seen something like that in many a year. So that was incredible. All right. Are the cinnamon rolls available for shipping delivery? I don't think so. Here's the thing. The breakfast company serves the freshest and tastiest food you've ever had. And I don't think there's any delivery service out there, even Uber, I don't think does it justice for how fresh it is and how delicious it is. Please consider subscribing to Dr. Joe Corcoran. Dr. Joe has his channel that he has set up. He's doing phenomenally. It's growing by leaps and bounds. He's looking at some other cases that are coming up and some other related issues that are similar to what was presented here in the Maya trial. And if you listened to this trial and you heard things and you said, hey, that resonates with me and I want to be part of something, I want to make a change, I want to learn how I can advocate for myself or for others, you'll want to be on his channel. You'll want to be a member over there and participate there, because he's bringing together just amazing people, and I will deliver them in my Audi. Cinnamon rolls in an Audi. That's a new business model. I'll have to explore that. Anyway, highly recommend Dr. Joe's channel. Let's see. Coming soon. If you order them, whatever it's worth to get them there hot and fresh is how you want them, because they're so good. I was just thinking about cinnamon rolls when checking out emojis. My wife just made trays and trays of cinnamon rolls. We like to give away cookies and cinnamon rolls and stuff around the holiday season. And occasionally we'll even go sing to the neighbors. Yes, we go caroling at Christmas. So our family goes and sings. I might even play the guitar if I remember how. But let's see. My wife was asking, Dr. Joe, do you understand the red cow reference? What they're talking about is in this response that Greg filed. They talk about a juror that she's the red cow juror. I have no idea what that means. If she had like a shirt that had a red cow on it, or is he talking about Red Bull and he means like the juror that was drinking Red Bulls? I'm just at a loss for what that could be. Let's see, what juror number was it? I have to do a find here. Find cow on this field. Oh, it's not doing it. Come on. It's on the wrong page. Well, we'll see if we can find it here. Control F, find cow. Go. Okay, the red cow juror. Juror number 97. This is the reference here, if we're looking at it. And thanks for the question, Mrs. R.A. Appreciate that. Homeschool Ground Zero is her name. The court need no look further than defense counsel's failure to inquire of juror number 97, the red cow juror. We just don't know. I've never heard that before. For proof that defense counsel would not have exercised a cause or preemptory challenge based on the affirmative response to 18A. Not sure what that means. So if somebody knows, Google red cow legal reference. I will do that here. I will Google all the things. Red cow legal reference. We've got just minutes before Kurt takes over here, so we've got to be quick. Not a Red Bull, not a red heifer. The term red cow is used in some legal circles, particularly in Florida, to describe a case that is directly on point. A commanding precedent. There it is. John Link. Thank you. We solved it. I'd like to say that I fixed it. I fixed it myself because I Googled it. So red cow means that it's the equivalent to a poster child for something. If you're the poster child for something, the red cow is the directly on point example for this. So you might have case law. You might have case law where you say, reference this case. This is the red cow case, where it's literally every fact of the case is identical to the one we're dealing with here. Kurt says, I've been a lawyer for 17 years. Never heard the legal term red cow. It's a Florida thing, apparently. I don't know, particularly in Florida. And we know this is true. This is dated April 12th, 2018. This is not something that just appeared on the internet yesterday. Red cow in Florida means case in point. So we need to dig deeper on this one. Where did it come from? The term red cow is used in some legal circles, particularly Florida, to describe a case that's directly on point, commanding precedent. It can also be spotted calf. What's with Florida and cows? I mean, I realize they have a lot of cattle down there. It'd be great for Ari and family to carol on stream. We're not that good, Renee. We're really not that good, and it's a lot like over in England. We did a little caroling when I was over in England as well, and in England it's different. When you go trick or treating, you knock on the door and people give you candy. When you go caroling in England, you knock on the door and people pay you to leave. They give you money, and then they shut the door, and that's it. So that's more of our experience. They pay us to leave when we go caroling. Petition to RA to come carol at all of our houses. Now, we might, I don't know. We might have to do something for a Christmas stream. Runkle's stream starts in 20 minutes too. I promised Kurt first. I one day we'll do a redirect to Ian, but I promised Kurt first. So next thing you're going to tell me is that Florida man is actually a legal term. Red Florida man, is that a thing? Red cow Florida man. The conspiracy of the red cow juror. Reddit is going to have a field day with this one. We need a red cow emoji. We'll have to get rid of an existing emoji because as memberships go up and down, because right by verdicts we get a lot of members and then they peter off on the channel. So I've created all the members I could when our count was high on memberships, and I can't make any new memberships until we get a lot more back. so we have to get rid of I have to update one of our existing emojis. So you'll have to agree on getting rid of one before we... 3 red cows, 3 maggots, and a maggot. 3 goats and a maggot. 3 billy goats and a maggot. Was that it? All right. Kurt's going to be live in about 2 minutes, so we're going to go ahead and wrap up here. Let's see. So Kurt's going to handle this. I don't know how late Kurt's going to go. It might be that Kurt educates us all and then transfers us over to Ian. It could happen. Stranger things have happened, and maybe Ian will come join Kurt. But we're gonna wrap up that way and call it a night. I appreciate all of you for being here. Thank you, Jules, for giving me the heads up that this document had been posted. We will keep our eyes open for the ruling that's expected from the judge this week about the juror interview, if it's going to happen or not. And then if it is going to happen, we don't expect anything else to happen until after the new year, at least in this case. Ian, looks like we're all going to end up in Ian's place eventually. So we'll start here with Kurt. We'll go to Texas. Then we're going to go up to Canada. So you guys buckle up. We're going to have quite a bit of travel tonight on YouTube as we jump around to some of my great friends and amazing legal minds here on YouTube. Can't wait for all of it. All right, thank you guys. It's been a lot of fun. Glad we could read this through with y'all. There was a y'all. That was a North Carolina just slid into the chat like that. We'll raid some channels tonight. We'll do that. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again. We have our court case. It is one from the archives. We're reviewing. It's a little bit crazy. It's a murder trial. It's Judge Newman, and it's from a couple years ago, but it's Judge Newman. It's before he handled the Alex Murdaugh trial. It's sort of like in honor of him, as he's retiring this year. He's no longer going to be a judge. He's served his time, and so here we're going back and looking at one of his great cases. We're on the middle of day 2 right now. We're going to pick that up at 9 o'clock in the morning tomorrow. So if you want to do that, please join us. It's a lot of fun. It's a fun case. By fun, I mean it's murder, and that's what we like talking about. So, because we're weird like that, right? None of our friends understand, but we all do. All right, that's all. Please be kind to each other. We're going to go raid Kurt right now. When he lands, please give him a thumbs up on the stream. Say something in chat. Subscribe. Do all the fun things. And other than that, please stay safe. We'll see you tomorrow morning. Have a good night. Bye. Link's coming right up. Don't go anywhere.